SJC-13776, Commonwealth versus Richard Holbrook, Jr.
Attorney Kelly.
Good morning, Your Honors. If it please the court, my name is Brian Kelly, and I represent the appellant, Richard Holbrook, in the case. There's a matter that I'm going to ask the court if they'll take under a 16L letter. There's been newly discovered evidence, and it goes directly, Your Honors, to an issue that the motion judge found to basically reject the claim of prosecutorial misconduct. The issue in the prosecutorial misconduct case situation was that the judge rejected it, saying this was just negligence on the part of the prosecution, and there was no intentional misrepresentation. This court actually, I've been before this court once before 7 years ago, in this court, and in their ruling actually found that the prosecutor themselves was misleading in the way that they presented the facts to the jury, claiming that there was nothing exculpatory at issue. The point.
What's the newly discovered part of this?
I'm sorry, I didn't hear.
What's the newly discovered part?
Newly discovered evidence, Your Honor, goes to the fact that this is not this prosecutor's first time doing exactly what she did in this particular case, being withholding evidence and tampering with evidence.
Okay, if you're raising new factual allegations, as you well know, there's no timestamp on a Rule 30 motion. So if you have new evidence of prosecutorial misconduct, you have the ability to file another, motion for new trial under Rule 30.
I understand that, Your Honor. In this particular case,
but I just think
I go to the court for you to tell me which is the best way for me to present this to you. This is not.
I just don't want you wasting your time with the 16L.
No.
Which raises new authority, this is a factual argument.
It's something that I would. It's something that just goes to another case, which the court would need to see.
That you just found out about?
Yes. No, I just found out. I don't generally go into BBO complaints, but there was one that was around. I literally just found out about it this week.
Right. But again, that's the beauty. That's the benefit of Rule 30 and the fact that you can file serial Rule 30 motions to raise factual allegations. Okay,
I just didn't want, because it's not. It doesn't involve any of the parties in this particular case, but it's something that I believe that the court should look at, because I think it is enlightening as far as what the BBO found in a case almost identical things in that one. That being the case, Your Honors, there are obviously there are both issues of ineffective assistance to counsel and prosecutorial misconduct. One of the key issues that I did want to present to the court was what I consider the lack of preparation in the case. It was the failure of trial counsel to basically retain a forensic expert, which goes against all of the case law cited in the El-Side case and the Baker case, and even the Kimmelman case. The motion judge, basically agreed that yes, there was ineffective assistance of counsel because trial counsel never bothered to retain an expert. He actually didn't know how.
Is this the computer?
The expert.
Is this?
And the expert, he testified at the evidentiary hearing that he actually didn't know how to get the information to his expert.
Are you discussing the forensic expert related to DNA testing, fingerprint testing, or the forensic test?
Computer, Your Honor. I'm sorry.
He did retain an expert, right? Workman?
That's that. Workman is what we call did not engage, fully engage.
So it's not that he didn't retain an expert, is that he didn't use the expert?
It's both, Your Honor.
He did
because what
retain
happened,
Workman, so
Your
I'm
Honor,
confused.
What did happen, Your Honor, is that the expert was retained.
Yes.
And never, again, you're correct, he never used the expert. But then when that happened and he dropped out, he never bothered to go get another expert, despite the fact that nothing changed from when he first took the case over until when he could have gotten another expert. There was no change whatsoever. It's just the counsel basically said, I just thought there was nothing on the computer to get, so I did not get it.
Counsel, could you address the more difficult question? And that is, even if he had done what you claim he should have done pre-trial, we still have to contend with ultimately what was recovered. And what was recovered, when you put that through a prejudice analysis, doesn't seem to suggest that even if you had done all of this, that it would have been of any substantive benefit to the defense, because the emails really didn't shed any light on the third-party culprit kind of argument here, because they didn't really underscore any real motive for why Mager would have wanted to kill this person.
Well, Your Honor, this court in the first appeal, which I'll call Holbrook 1 just for ease of referencing them, did find that there was information that if the emails that were recovered later were brought out and shown to the jury, it certainly would have put Marr's credibility at issue, and which I believe the Chief Justice actually authored the Holbrook 1 case.
Yeah, but you're skipping over Judge Sullivan. Okay, so when it went back and Judge Sullivan considered this claim, Judge Sullivan found that it was marginal having any probative value, that the emails largely only established that there was some kind of emotional attachment and reconciliation efforts. There weren't any, the new emails didn't establish any kind of coercive, threatening, extortive, and Meager already testified to having slept in that bed for 2 years. So again, we're talking about what you actually found in terms of the prejudice analysis to animate the ineffective assistance computer forensics person. So could you talk about why Judge Sullivan was wrong there and he made some kind of an error, abuse his discretion with that?
Sure, yes, Your Honor. The issue there is that there was potentially, and I can't tell you that there is, I'm not a computer person, and the only thing I could go by is what was said, and it was actually said by the expert for the Commonwealth, Sheriff Perry. But the issue came up in which he said he could have gotten into the emails at a later date. The expert that my predecessor, appellate counsel, Mr. Fuono, did find some emails, but he delivered an affidavit which was presented to the court that there could be, again, I cannot say positively, but there could have been more emails just because the technology had gone so far since the first time it was looked at. And when this court gave rise to allowing us to have the third-party discovery done, what came out was that that all of the hard drive and the copy are no longer.
What happened to defense counsel's copy?
Sorry?
What happened to defense counsel's copy?
I'm sorry, I'm having trouble. I apologize.
So I understand that during the trial, there was no examination by the defense of any extracted data from the computer.
Right.
Following the trial, the defense was able to access the computer.
Yes.
And do an analysis that shows the last communication from the victim to Meager was over a year before the murder.
Yes.
Defense counsel must have had a copy of the extracted computer. And I understand that the state's copy is gone. What happened to defense counsel?
Defense counsel returned the forensic copy to the sheriff.
Where is that in the record?
I will have to get that for you, Your Honor, but it is.
Why would that? That doesn't make any sense. Anyway, yeah, I would love to see, if you have that in the record, that would be great to see.
That kind of goes to the point that this is the way this case was handled by trial counsel. There was a.
Oh, this was post
Okay.
Conviction discovery.
Yeah, I believe it's the affidavit. I can cite that to you post our argument here. That Verono, who was the one that he was the expert that unearthed the emails. Verono did. I think he also said that he returned. He returned that to the sheriff. Why? I don't believe he said, but I believe, Your Honor, it's in there that says he essentially allowed the.
But the point remains that if there's no copy that can be forensically examined now, and we know what was on the drive that was capable of examination, there's no evidence to suggest one way or the other whether there would have been anything more on a subsequent examination of the drives, right? You just aren't able to tell us.
That's exactly right.
So who has the burden of proof in showing prejudice when you have nothing to show here?
I would follow, Your Honor, I would ask the court to follow Commonwealth versus Connolly, in which there was, in that particular case, it was the defense counsel's own lawyer who lost the evidence. So in that case, they asked for the knife to be examined, and the lawyer said he did, but didn't do that, and eventually it got lost. And the court came back in Connolly and said, since we can't tell, it's prejudicial against the defendant, and the defendant deserves a new trial, and also deserves to be explained to the new jury that why there's an absence of that, and who's responsible for the absence of the evidence. In this particular case, it's not the trial counsel's fault that anything was lost, but in this particular case, because of all the antics that were brought up by as far as the prosecution went, as far as holding off, we have an affidavit from Verono that says that we can probably do more, but again, it's not. It was all the things were lost at the hands of the Commonwealth. The state police lost the original. The forensic copy was damaged in the hands of the Plymouth County Sheriff's Office, and for the judge to basically what he said, Judge Sullivan, what he basically came up in his denial of the motion for new trial, he said that he was incorrect, and he said it was never available. So basically, no harm, no foul. This was never. It certainly was available, Your Honor, but because of the way it was mishandled by the prosecution, yes, it's prejudicial. We don't know.
Does that go to the speculative part of it, though?
Well, I mean, it's at some point in time, and it's a situation where if nothing was through any fault of the defendant that he has been prejudiced, because there was information. We have experts at least opining that there could have been. I understand we don't know. As I said, I'm certainly not the guy that would know that. But the fact of the matter is that there was so much interference by the Commonwealth as far as getting the hard drive together. And then of course.
Do you think that the possibility that there might be something that could be discovered further needs to be weighed against the strength of the evidence against your client?
Sure, yeah, I absolutely do, Your Honor. And
here-
I would also
yeah.
point out that this court in the Holbrook 1 case pointed out that the evidence against the defendant was equal to the evidence that was against the alleged third-party culprit, Marr. Basically, this court in the Holbrook 1 case said both had to do with credibility, and there were.
Did it really say that that the evidence was equal?
I'm sorry.
Did it really? I just don't recall that case saying that the evidence was equal.
Maybe I obviously I don't need to put words into the author's mouth, but it basically that this court found that either allegations or the evidence was when it was right. In fact, I did cite it in the brief. That it was equal as just as much. Basically, there's just as much stuff against Marr as there is against Holbrook, as far as the identification.
Can I ask you about the DNA so I understand the strategic part of this and get your take
Sure.
on it? As I saw it, there's a wallet that has DNA that's not the victim's, near the bludgeoned victim, as Mr. Greenberg said in his closing argument. And the defense attorney chooses not to have it tested for DNA. He's trying to pin it on the third-party culprit. He's able to say he's able to bring out the fact that there's DNA not tested. He's able to say in his closing argument, I want you to focus on the wallet and the DNA. The government didn't test it. And he's trying to draw the inferences, like saying, well, there's third-party DNA on it, so it's got to be meager. If he had tested it and it came to meager, am I saying it right? Is it meager?
It's actually pronounced Marr, like M-A-R-R.
Okay.
It
So
looks like meager, but it's pronounced Marr.
it's Marr. So if he tests it and it's Marr's DNA, he can't make that argument in good faith and close an argument. If he leaves it alone, he can make that argument, correct?
Well, I suppose he could, yes, Your Honor. The thing is, though, I mean, obviously,
So
we don't have
explain
to
how that's-
prove it's Marr. All we have to disprove that it's Holbrook.
But it's a gamble for him to have it tested.
And I would actually
I think that's what Judge Sullivan found, right?
respectfully disagree with that, Your Honor, for this case, for this instance. If it turned out that it was there, then the worst scenario was exactly what everyone's saying. Well, there's no harm for it because we would have expected Marr's DNA to be on the wallet. I mean, he lived with the guy for 2 years, and he just visited him a month
No, I think
ago.
the danger is if the DNA testing showed it was not Marr. How do you deal with that? If Marr is your third-party culprit, now you've got DNA testing saying it's not Marr on the wallet. Doesn't that hurt the defense case?
I don't think any worse than leaving it alone does,
Really?
Your Honor.
Because at least with leaving it alone, you have the Bowden argument that the police didn't investigate this. And you have a suggestion, and you know it's not the defendant, so you can say it's not mine.
Right.
Yeah. So that seems like a good argument.
I mean, obviously, it's. I mean, we don't know, of course, whose it is.
But is it within the realm of strategic decisions of a defense attorney? That's what I'm trying to inarticulately ask you.
Yeah, I don't. I mean, personally, I mean, I don't. I think it would have been worth the risk. He doesn't risk anything worse.
But is it manifestly
And if it is found, Your Honor,
reasonable?
yes, he's in the same position as he would with the speculation that Judge Sullivan comes with. Well, it could have been his. Yeah, it could have been his. It could have been. We don't know that. Again, we don't have to prove it. But in order to.
But most defense counsel, I think, would not want to do something that could potentially add to the quantum of evidence against their client.
If you can believe the defense counsel himself, defense counsel was pretty forthright in saying, I didn't know I couldn't do this. And I know that Judge Sullivan has made
He doesn't credit that.
Post-conviction, you also had the option under 278A to have the wallet tested, correct?
yes. We didn't get that far. We just got to the Holbrook, the trial matter, Your Honor. Yes, of course. Unfortunately, I think you're gonna shut me up. But I rest on the brief, Your Honor, and I did say I would like to get information to the court, which I think will shed new light on the situation as far as them negligently and not intentionally in the way the prosecution dealt with the case. Thank you, Your Honor.
Thank you. Attorney Burbine.
May it please the court, Carolyn Burbine for the Commonwealth. It's our position that given the strength of the Commonwealth's case here, the identification evidence, the fact that the defendant was, according to George McDonald, who picked him out of a photo array in the victim's apartment shortly before the murder. He was there from 11:20 until 12:08. And at 12:23, there was the hard shutdown of the computer, which is on the Commonwealth's theory when the murder occurred. At 12:45, the victim's mother saw a man fitting the defendant's description in the victim's car. At 12:49, that man drove off in the truck. At 1:03, it arrived at Stop and Shop, and the person went into the Coin Star. And at 1:25, the truck was left behind. And all of the evidence about the defendant having money after the murder, when he had previously had no money, needed money, was homeless. And just the thorough investigation that the police did, which had surveillance videos, multiple witnesses that were questioned, just the wealth and strength of the Commonwealth's evidence, I would say that there is no prejudice from any ineffective assistance of counsel finding by Judge Sullivan as far as the forensics expert is concerned. And Judge Sullivan indeed himself found that all we were left with are emails from the deceased to Mar showing that he missed him, to show that no animosity, that we're not close in time to the murder. And there's nothing in those emails that creates an inference that there was any animosity or this theory of attempting to extort the victim. And
So could you just, because I'm a little bit confused as to counsel's answer to Justice Wendland's question, can you just give us a little bit more detail, if you have it, about what happened to these hard drives?
Yes, the Commonwealth, there was an original which had been sent from the Secret Service to the Sheriff's Department. That original, the state police could not find it 18 years later or whatever it was when the defense sought it post-remand, post-conviction. And then the Commonwealth the Sheriff's Department did have its copy of it. However, it turned out to be damaged, and we sent it out. We all agreed that we would send it out to a data recovery company in California, but unfortunately, they determined that it had some kind of a malfunction, and we couldn't get the information off it. And then, I believe it's in our stipulation, we indicated that the defendant's expert who had found the emails said that he did not retain his copy. I did not take that to mean that he returned it to the sheriff's office. And we had my office known that, we would have said to the sheriff's office, you also have Verano's copy. And we did not.
So you have the Secret Service copy to the sheriff's was lost.
Yes.
And your retained
Well,
copy?
I'm sorry, the original, so what happened was the original was in the tub. The sheriff's office sent the original out to the Secret Service in hopes that they could retrieve what was on it. The Secret Service sent it, actually, I think they sent an image, but I think they also sent the original back too. And everyone worked off the image, not the original.
And the image was corrupted somehow?
And 20 years later, when we went back to try to use our copy, it was corrupted.
So I guess the problem, I guess, is that we're doing this prejudice analysis, and we have this hard drive that, not saying it was intentional, but was mishandled by the Commonwealth in one way, shape, or form, wasn't it?
I wouldn't say it was.
concede at least that?
I wouldn't say it was mishandled. I would say that we held on to it, we retained it, and it had some kind of. I don't know. I don't recall the data recovery company saying whether it was due to age or exactly.
Head crash.
I'm sorry, head crash.
think they said it was
some kind of
head
rubbing of something that.
But that doesn't explain losing the original.
Right.
True, but defense counsel also had their copy, and they didn't retain it either. So both sides have an issue here. I mean, they should have had their copy, and had they retained their copy, hopefully we could have tried again with their copy. But again, this is still pure speculation that anything additional could have been retrieved at all. This had been submerged in a bathtub for 24 hours. And counsel did have the opportunity in the first motion for new trial to try to find something on it, and found only outgoing emails. We have no indication that isn't all that there was to find. It's all speculation that there's new technology that would pick it up. We don't know.
So opposing counsel suggested there was some affidavit to the contrary, that Verno's affidavit suggested that there could be further.
But I think I think he says it's a possibility. I don't think he says, oh, it's definitive, we absolutely have it. I mean, I think it's still speculation. And with what we found, and again, this had been in a tub of water and put there deliberately. So I don't think that, and we did hold on to ours. There's no indication that anyone deliberately put this somewhere that it would get damaged or didn't take care of it. It's just that when we went to retrieve it, and I think we may find that this happens, in the future. We're all relying on we have this stored here in this technology, but things get scratched, things get moved around. It's just, I don't think these things are as sturdy as we'd like them to be. And 20 years.
But the problem that I'm still struggling with is, we know that there are convictions and that there's post-conviction litigation. You know, when you have murder one, they've got the automatic right of appeal. So you know that these things have to be preserved. And so trying to figure out, doing this, this divining of how prejudicial something could have been or not been when we don't know what potentially existed. I'm trying to figure out how we really measure that in the context of the Commonwealth lost this hard drive, and the other part wasn't preserved in a way that we could do anything. Notwithstanding the defense could have done something with their own, but how do we deal with that?
I think that there's no showing of bad faith by the Commonwealth. There's no indication that someone, deliberately put it somewhere that they shouldn't have or didn't take care of it. And we also don't know if this is something that's normal with age. Could this be happening, just by the passage of time and the delay in raising this issue, which is not on the Commonwealth. So, and then I think that still we also have the fact that we had such a strong case, and Maher testified at the trial, and defense counsel had the opportunity to cross-examine him and try to cut against his credibility. So, and even if, I would posit that even if there were emails that showed that Maher had not been entirely truthful about his amount of contact with the victim, I don't see how that would cut against the fact that he had an alibi and that all of the identification evidence in this case. I just feel like given the strength of our case, that Maher testified that the jury could look at him and look at the defendant. What do they look like? They don't look alike. Maher was described as short. The defendant is consistently described as tall, skinny, rotten teeth, always wears a Carhartt jacket, and through the entire trial, we have people describe him that way, and some of them knew him, some of them knew Mar. The mother had seen the person outside rummaging the car. She knew Mar, said it was not Mar. The neighbor knew Mar, said it was not Mar, and they both described the defendant as the tall, skinny man in the car hat jacket.
Can I ask you to address the prosecutor's closing argument where it was specifically referenced that there were no emails on this hard drive, even though you could still look at it, and that they were of no evidentiary value whatsoever?
At the hearing, she explained that the context of the no evidentiary value statement, she said that, that the meaning of that, and Judge Sullivan credited her at the hearing, was that, and Perry actually also on recross said the same. Perry testified that from the reports, there was nothing of evidentiary value found on the hard drive. And then on recross, he explained that by no evidentiary value to items, he meant something in the case that would help, like the webcam. And then the prosecutor also testified at the hearing that, again, when the experts viewed the computer, the context was it was narrow. They were talking about it in the context of what limited information they were looking for on the computer. They were looking on the computer solely for webcam footage, hoping that there would be something
See,
filmed.
that's why I asked the question, because the prosecutor doesn't confine the argument to webcam footage.
Right, but Perry
Specifically says they're still able, despite the water damage, they were still able to browse websites and to check emails. And Perry told you, ladies and gentlemen, that there was nothing of any evidentiary value on that computer. So the prosecutor specifically referencing not the webcam that they were looking for, but the emails that it turns out some did exist.
Well, Perry had, as I said, Perry had.
And I guess my question, just to put a fine point on it, is not whether there was some basis for the prosecutor to have said that, but the prejudice analysis now that we are in the second motion for a new trial, given the reliance of the prosecutor in closing on the failure to have emails, how is that? Just explain to me the government's position on how that's not prejudicial.
Well, I believe that the defendant in his closing had gone into how, there was a shoddy investigation, the emails, you heard from Perry that there were emails and he didn't look at them. So I would posit that the prosecutor was answering that. And then the court, closing arguments, you look at them in the context of all the evidence and the context in which they're made. And here we had the jury, and the jury gets the instructions. So they got all the instructions that you need, that the closing argument is not evidence. So if the prosecutor misspoke or mischaracterized it, they still had Perry's testimony explaining that by no evidentiary value, he meant something in the case that would help, like a webcam. So he wasn't talking about email, and they'd already heard from Perry that no one had looked at emails. So I think she was trying to counter that specter that was raised by the defendant of a shoddy investigation. But I don't feel that the jury would have taken that, in the way that could be dangerous to the defendant. I just don't think that it's there. And again, given the strength of the case, that comment in a closing argument would not have been definitive and skewed the verdict, in my opinion. Did the court have any further questions? I would be content to rest on my brief.